the already fantastic speeches that you wouldn't really want to listen to it. But I've assured Alex that you've got no choice. And that the doors are locked, so you're not getting your butties anyway. So please welcome Alex Ruck, Keene.
Thank you very much. I think you are actually about to hear a first, which is probably the first time ever that a legal lecture in the half hour before lunch comes as a bit of a light relief. I feel, frankly, utterly fraudulent standing here after the speakers you've heard this morning, in particular Sarah and Margaret Flynn, and I'm not just ignoring Norman Lamb because he's not here. What I wanted to do with you is, I'm afraid, it's a bit of a law lecture, but it's a bit of a law lecture. Thank you. It's a bit of a law lecture where I just want to take this opportunity to lift our eyes a tiny bit above the horizon and to think about some of the areas that law might possibly be going. But actually, in particular, well, right at the very end, I might just want to reflect very briefly in light of especially what we've heard this morning about what actually the place of law is here at all. So the title of my talk, which I managed to smuggle past Neil, was Fusion by the Back Door. And it's really asking this question: what place does or should capacity have in mental health admission and treatment? And I was going to look very briefly at the statutes, the soft law, the code of practice, and then a couple of reported cases which I think show us some interesting stuff here. The impact of Cheshire West. Those of you who know I'm at the Law Commission will also know that any time I speak, I'm not allowed to talk about anything from our project. Please don't ask me. I'm getting quite good at getting evasive. But I just want to look at the impact of the Cheshire West decision specifically on what I'm talking about now. And then I just want to finish on some visions of the future, possibly with be careful what you wish for. So very briefly, you know this. There's no mention of capacity in the core MHA admission treatment provisions. And the MCA, which came along later, made it very clear that in principle, the MCA should not be interfering with the Mental Health Act. And it says, in essence, you can't authorise anyone to give a patient medical treatment for mental disorder or consent to a patient's being given medical treatment for mental disorder if they're having Part 4 treatment. So tanks off the MHA lawn, please, Mental Capacity Act, reflecting this long-standing division that the Mental Health Act exists in its own little world and the Mental Capacity Act exists in a parallel universe. That's the statutory position. Well, obviously the statutory position did start to change slightly with the 2007 Act, and it has started to sneak in capacity. We've got capacity in the context of ECT. We've got capacity in the context of adult community patients, Section 64D and also Section 64G. And we've got 16 and 17-year-old informal admissions. There are express references to capacity, Mental Capacity Act, and various of the instruments relating to the Mental Capacity Act, like advanced decisions, like the powers of deputies and attorneys in the Court of Protection. So it started to smuggle stuff in there. Through the practice of, or through codes of practice, the government is trying to give us, or DH is trying to give us a message that could we please think a bit more about capacity when we talk about mental health patients, people detained under the Mental Health Act. I always find quite interesting doing find and replace, or at least find when you're looking at documents, and I thought I'd share with you a mildly amusing statistical exercise I did, which is how many references are there to mental capacity in the new English Mental Health Act Code of Practice compared to the 2008 one. And they quite usually come up with almost exactly double. 2008 edition, 54 references to mental capacity. 2015 edition, 133. And then an entire chapter on mental capacity and deprivation of liberty, which does actually try to say slightly more than just about which one do you use of Doles or the MHA. And this relatively strong statement, I mean, strong for soft law, it's saying the Mental Capacity Act should be central to the approach professionals take to patients who lack capacity in all health and care settings, including psychiatric and general hospitals. The starting point should always be that the MCA should be applied wherever possible to individuals who lack capacity and are detained under the Act. I, for myself, would love to know whether that's your experience. I would in particular love to know whether it's your experience that people who are detained under the Mental Health Act are mysteriously then thought to be somehow not necessarily worth thinking about the MCA in relation to. And the power of the MHA being used to say, well, we can control contact. We can control every aspect of this person's life. We don't really need to think about the MCA. But in principle, the Code of Practice is telling us the mere fact we've got the MHA, which is in place to give authority for detention and maybe providing authority in relation to treatment, does not give us any authority in relation to anything else. For instance, physical treatment unrelated to mental disorder. That is meant to be straight down the line. Does this person have capacity to consent? Yes, do it on the basis of that. Do they not? Then please go away and think about Section 5 of the Mental Capacity Act. Again, love to know whether that's your experience in inpatient settings. But that is what the soft law is trying to tell us. And then we've got a couple of cases, because it couldn't be a law lecture without a couple of cases. The first one, I actually think I do an awful lot of training of doctors and nurses and social workers, and most of my training consists of giving them, or most of my training where it involves cases involve judges telling people they've got it catastrophically wrong. It's quite nice every so often to relay a case where the judge actually makes it clear that someone got it fundamentally right. Some of you may well know this case. It's an intensely misleading case. Someone should probably have told Mr. Justice Mostyn, please don't use the initials RC when there's an RC involved. Because it makes it sound like this was the entirety of Nottinghamshire Healthcare NHS Trust taking on an RC. No, it wasn't. The individual in question, their initials were in fact not RC at all, but they were said to be RC for these purposes. And I'm sure some of you will recall this case. This was a man who is said in a judgment to be a Jehovah's Witness. Someone involved in the case said, no, he wasn't. He was wanting to be a Jehovah's Witness. But anyway, he was detained. He was profoundly unwell, detained under the Mental Health Act, and very badly self-harming by deeply, deeply slashing his wrists. He was therefore going to be needing blood transfusions to save his life, very likely. Because he was seeking to become a Jehovah's Witness, he was seeking to say, I do not wish to receive blood. He made an advanced decision, tried to make an advanced decision to refuse such treatment, got it witnessed, all the formalities. He was lucky, I think, to come up against a good RC, a good responsible clinician, who said, yes, I could use Section 63 here, because his self-harming is a manifestation of his mental disorder. Section 63 says you are allowed to smuggle in blood transfusions as part of treatment for mental disorder. I could use Section 63. But she obviously had been to see Spider-Man quite recently because she felt, I have great power under Section 63, but I need to think about whether I'm using it responsibly. And she said, I feel conflicted here. I feel troubled about whether I should use this power under Section 63, because I think RC has got capacity to refuse blood transfusions. He's also made an advanced decision, which seems to me and to everyone else around me to be valid and applicable, made with capacity and to cover it and to have all the relevant bits of paperwork. Her trust, and it is nice to see every so often a trust actually backing up their clinicians, took the matter to court because they were very concerned that the obvious consequence of complying with RC's capacitus refusal and the ADRT would be that he was very likely to die. And they wanted to make sure that this had actually been properly thrashed out in court. They got before Mr. Justice Mostyn. Those of you who know my slightly tense relationship with him in relation to deprivation of liberty, I'm not going to be rude about him here because he got this one, I think, right. He said, as a COP judge, Court of Protection judge, I am absolutely sure this man's got capacity, and I'm absolutely sure that this is a valid and applicable advanced decision, sitting as a COP judge. Sitting as a COP judge, he couldn't do anything in relation to the Mental Health Act. That's not his terrain. but he said, I'm going to put a different hat on, and as an admin court judge or Queen's Bench Division judge, I am going to stand here and say, I do not think it would be right to exercise the powers that are available under Section 63 to impose treatment. And he says, I know that ADRTs can be overridden if you're doing treatment under Part 4, but you need to give very serious weight. He says, obviously the express wishes of the patient be highly relevant. If there's an advanced decision under Sections 24 and 26 of the MCA, this will weigh most heavily in the scales. And he goes on to get waxed quite lyrical about the Hippocratic duty. Any doctors in the audience, I know the Hippocratic duty doesn't exist anymore, but you can see what he's getting after. And then he concludes in proper Mr. Justice Mostyn ringing tones, in my judgment, it would be an abuse of power in such circumstances even to think about imposing a blood transfusion on RC, having regard to my findings that he presently has capacity to refuse blood products, and were such capacity to disappear for any reason, the advanced decision would be operative. To impose a blood transfusion would be a denial of a most basic freedom. As with almost all cases, we have no idea what happened. So I'm afraid I can't give you the follow-up. But that, to me, is a pretty ringing statement of a judge putting the capacity tanks very firmly on the lawn of the Mental Health Act. So, interesting forms of fusion possibly coming in. The other one is this one. I just wanted to relate to you. NHS Foundation Trust and Ms. X. This was a lady with anorexia. Her anorexia was very severe. Her BMI was very low. The treating trust kept offering her treatment. She was currently in the community. The treating trust kept offering her treatment, which she was declining. The treating trust took the view that they could seek to admit her under the provisions of the Mental Health Act because she probably met the criteria for detention, and they could impose force feeding under Section 63. They were, however, concerned as to whether this was really the right course of action. I'm putting right in inverted commas because encapsulating something which isn't necessarily legal. They came to the Court of Protection because this lady, they felt, Ms. X, did not have capacity to make decisions as to her feeding. Interestingly enough, she also had a problem with alcohol, and the evidence was, and the judge accepted, that she had capacity to make decisions as to drinking, but she didn't have capacity to make decisions about feeding or about her food intake. And the judge didn't actually hear from her, although Mr. Justice Cobb is one of the new breed of High Court judges who's quite willing to go and see people. He didn't actually hear from her because it was considered it might be too distressing for her, but he heard very eloquent evidence from her best friend, and he also had a document from her expressing very, very strongly that she did not want to have treatment imposed upon her. And the judge said, I accept she doesn't have capacity to make these decisions, therefore the gateway's open. I could, as a COP judge, say it's in her best interests to receive treatment, forcible treatment, force feeding. But he granted a very interesting declaration. Sorry, interesting is never a good word for anyone other than a lawyer, but to me an interesting declaration. He said, it's not in Ms. X's best interest to be subject to further compulsory treatment and detention of her anorexia nervosa, whether under the MHA 1983 or otherwise, notwithstanding that such treatment may prolong her life, and it's in her best interest and shall be lawful for her treating clinicians not to provide her with nutrition and hydration with which she doesn't comply. Again, you can see what he was trying to do. He had formed a view, after very, very careful consideration, she didn't have capacity. He'd also formed the view it wouldn't be in her best interest to compel this treatment. Interestingly, though, from a legal perspective, he then sought to do something which, in my view, he just simply wasn't allowed to do. He could not pronounce, as a COP judge, what any MHA professional should or shouldn't be doing. Any MHA professional should be applying the terms of the Mental Health Act, so the clinicians would need to be going, do I make out a medical recommendation? And then one of you AMPs, or those AMPs in the audience, one of you would then have to decide, should I be making an application? A COP judge can't be telling you what you can and can't do. because of the way in which the case had come to court, it was going to be very obvious that no one would be trying to make a recommendation on the medical side in light of his finding. And again, that is just not a car crash, but that is a real coming together of principles related to capacity, and in this case, incapacity and best interests, combined with the Mental Health Act, in a way which, on the face of the two statutes, don't sit together. On the face of the soft law codes of practice does start to sit together, and then does lead to some quite interesting questions about, are we achieving some kind of fusion between the two by the back door? Before I look at some of the future things, can I just stop for a second and just think about the impact of Cheshire West? I appreciate the impact of Cheshire West is in part to bring about the collapse of Western civilization and the onset of a new form of psychiatric disorder. I'm very glad we've got Dr. Tom Burns here so he can help us with what should be in DSM-5 or DSM-6 about Dole's depression, of an overriding, overwhelming desire to go and do anything other than think about this area. But one interesting thing that Cheshire West, I think, has shown us is, and I'd be interested to see whether you agree with this, I don't think, especially given the bed crisis, you are going to be admitted to a ward or a dedicated unit or a dedicated psychiatric hospital in this country for a treatment and assessment and treatment of mental disorder unless you are going to be confined. You are going to be continuously supervised and controlled, and you would not be allowed out unless the staff decided it was okay. They would probably dress it up in, if you tried to leave, we would have to consider whether to invoke Section 5. Sarah spoke very powerfully about misuse of language this morning. I would like to suggest to you, we will consider the use of Section 5 very dodgy statement. Because the second you say, come on, professional to professional, you wouldn't let them go. They go, of course we wouldn't. So I think it is very difficult to say that people are not confined. The acid test is not satisfied, which means capacity is key, because it's otherwise going to be a dole. What we are waiting to find out, and with bated breath, because given the Court of Appeal heard this in June, they still haven't given us a decision, about the extent to which capacity can be key for unlocking, for instance, conditional discharge. In other words, if you've got capacity to agree to conditions on a conditional discharge, and you seek to do so, are you actually going to be allowed to do so? Because RB, the old Court of Appeal case, suggested, in essence, you couldn't. Because you had Hobson's choice. It was a constrained choice, so it might be a capacitor's choice, but it's just not an actual choice. Mr. Justice Charles in MM tried to say, you can have a rubbish choice, but you could still have a choice. And that's looking at conditional discharge. I'd like you to think, by the way, if you might, about whether that logic, if the Court of Appeal upholds it, which I hope they do, does that not apply for informal admission? Because there's something interesting about informal admission, I've always thought, and I've never really got to the bottom of it in a way I'm particularly happy with from a principled fashion. If you're giving the information that you need to give to someone to assess their capacity to enter into confinement, including, by the way, an element of our confinement, your confinement is we will use Section 5 on you if you try to leave, are you not coercing them? Yes, probably. Is it legitimate coercion? Possibly, because someone having a status, an informal patient who has capacity to make relevant decisions, is in a different position. You can't use Section 4 on them, Part 4 on them, rather. Really interesting stuff. George Schmuckler, some of you might know, the hippie psychiatrist, or he gets very cross when I call him that. He's doing lots of interesting work about this elements of constrained choice. And the fact we pretend it doesn't exist, elements of coercion, are we just allowing stuff to go on? Should we be more transparent? But again, this is looking at capacity, thinking about how all of this works out. And Cheshire West has really brought this to a head, I think, by making it crystal clear, if you're honest with each other, we're honest with ourselves, you cannot be in a psychiatric hospital without being confined, so therefore there has to be capacity to consent to that confinement. Right, let's just look to the future for the last few minutes. Some of you might know the Mental Capacity Act, Northern Ireland. They did in March this year, decide to take a very brave leap, on one view, into the complete unknown. They are pretty much the only jurisdiction in the world which have sought to fuse mental capacity and mental health legislation. A lot of that actually comes from what Norman Lamb was talking about, the same idea that unless you give absolute, or a way to give parity to mental health treatment and physical health treatment is to just have one model and not to allow mental health treatment to be looked at separately. That's where this all came from. And the Bamford Review led to this. And in essence, you are not going to be able to be detained compulsorily for mental health treatment unless you lack capacity to consent and it's considered to be in your best interests. You will perhaps not be entirely surprised to understand that best interest has a slightly wider definition in Northern Ireland than it does here, because that best interest can also include the risk of harm to others which might rebound on you. I'm paraphrasing. Because otherwise, you can imagine the public protection concerns. And they've got to grapple with that, and they feel that the principal way to do that is to grapple with it by lumping it all under best interests. It's some way off. They passed it. They've realised they are going to have a serious job on their hands to get a piece of legislation and all the secondary legislation and the codes of practice, and to change a culture in Northern Ireland which is different in some ways in this regard. So the codes of practice aren't going to be drafted. They're being drafted at the moment for public consultation early 2018. We've got that, and I'll come back to that in a second. We've also got, and actually it's interesting, we haven't heard anyone talk about the Convention on the Rights of Persons with Disabilities so far, in the context of, for instance, new legal rights. We have out there a very strong statement from the Committee on the Rights of Persons with Disabilities saying the denial of legal capacity of persons with disabilities and their detention in institutions against their will, either without their consent or with the consent of a substitute decision maker, is an ongoing problem. This practice constitutes arbitrary deprivation of liberty and violates Articles 12 and 14 of the Convention. And they also say that forced treatment, in other words, treatment either against someone with capacity refusing or where someone doesn't have capacity on the basis of some kind of formulation of wishes and feelings, someone else's formulation, that's unlawful. And I heard the Vice Chair of the Committee on Persons with Disabilities a couple of weeks ago reiterating in no uncertain terms, forced treatment is unlawful, contrary to the Convention, must stop. Deprivation of liberty on the basis of disability is unlawful and must stop. That's a fairly massive and fundamental challenge to everything that we do in this country. We've also got, and I haven't put it up there, but just to flag up for you, because really this goes to, in particular, what Sarah was saying, Article 19 of the Convention, the right to independent living. And that's so much coming from, we should not be warehousing people in institutions, Winterbourne View, say, because it's easier for everyone else. That is fundamentally wrong. We've got the Convention, so the committee will be reviewing the UK's compliance with the Convention next year, and it's obvious what they're going to tell us. So if we want to be thinking about new laws, new legal rights, that is a place to be thinking about it. But I don't underestimate the scale of the challenge to the legal system as it currently stands. So, just concluding thoughts. Fusion so far, as I say, actually, I think by the back door, we are getting fusion. And I always find it interesting asking psychiatrists whether they feel happy detaining people under the Mental Health Act if they think the person's got capacity. And they always get a bit wibbly at that point. That's obviously a technical term. The harm to others aspect's fine, but if it's in terms of harm to self, Mental Health Act allows it. But especially the younger generation, newer generation of psychiatrists who have brought up in some ways more the Mental Capacity Act, they feel much more strongly about capacity. So they're already starting to smuggle it into their own practice. We've got the codes of practice trying to bang that message home. We've got the case law. We've got judges saying, OK, you may have this regime that you can use, in particular Part 4, but please, actually, you have to take the principles of the Mental Capacity Act seriously. Prospects for future fusion, without revealing any confidences from the Law Commission proposals, it would have been fairly blindingly obvious from the interim statement that we aren't proposing fusion. That's not necessarily because it's not something which may not be a good idea. That's just not on the horizon at the moment. It might be in a few years' time when one sees how the Northern Ireland Act has bedded down, and in particular sees how it's bedded down. But can I just ask this question? Do we want to be careful what we wish for? Because I have to say, thinking about the MHA-MCA interface, as I spend far too long each day doing at the Law Commission, in a personal capacity, makes it very difficult to see why one shouldn't have a fused law, because otherwise you're forever trying to allocate people to one or other box, when actually a person will present with a series, by and large, a series of things which need addressing, some of which are physical health and might be related to the Capacity Act, some of which look like mental health, and you're thinking mental health, and you're going, I've got to allocate someone to one or other a box on some, frankly, arbitrary dividing line, so fusion would be great. And the Northern Ireland Act has taken that idea that people are people and can't be just divided off into mental health problems, and therefore, as we've heard really eloquently this morning, perhaps somehow less worthy of thinking about, or physical health problems which we all feel a bit happier with. My massive concern, if we did go to complete fusion, is that we'll then just recast everybody who does what we don't like as lacking capacity, go around doing stuff in the name of their best interests. And we're already seeing that under the Mental Capacity Act. I know that any of you who read mental health law online, there's been a discussion recently about the extent to which you can take into account harm to others under even our provision of best interests. And you've got lots of slightly dodgy case law saying you're allowed to take into account the fact that someone might, you can stop a paedophile going around possibly interfering with small children to protect the person, the paedophile, from being beaten up by the child's parents, and therefore that's best interests. That's, to my mind, a slightly strained version of best interests, and I'd quite like to be just said, this is public protection. So if we do start moving towards fusions, we get in some very interesting areas about what we actually mean by capacity and then what we really mean by best interests. But anyway, that's what I really wanted to say to keep you kind of hanging up or trying to take you a little bit away from some of the stuff we've been talking about this morning to try and think about where we might be going. I always have to do this, not least because my clerk is here and he'll hit me if I don't. I need to do 30 seconds of promotion. Please look at our newsletter, Mental Capacity Law newsletter. That's the web link at the top. Those of you who haven't seen the Sky MCA directory, it's got some quite useful stuff. My website, Mental Capacity Law and Policy, full of random witterings. Mentalhealthlaw.co.uk, brilliant discussion list. And there are some books. Thank you very much.
Thank you very much, Alex.